All right, guys, welcome back to Law News Network. We're now fortunate enough to have as our guest Adam Gana. He is the managing partner at Gana LLP in Chicago and here to talk to us about all things Bybee. Good morning, Adam.
Good morning, Heather. How are you?
I am great. How are you?
I'm fine. Thanks for asking.
So I know that you've been watching this case along with us, and I know that, first of all, the testimony that we've heard this morning has not been the most interesting. Let's start there. How do you think the attorneys have done, well, the prosecutor, who's the only person who has questioned this witness thus far, how do you think he has done in keeping this as interesting as one can do?
Well, look, Heather, this isn't Law and Order. I mean, when people watch this kind of thing on television, you're not going to get the exciting bits more often than not. Being an attorney is exciting maybe 5% of the time. So you got to get through the drudgery because it's important when you're trying a case to make sure that you cover everything, whether it's exciting or not. It is what it is.
Yeah, I do think this witness in a lot of ways is a little bit more engaging than many of those we see when we're covering this type of evidence. He's tried to really make it more personal, sometimes to the point that I might be objecting. I think he's interspersed a little bit of his experience outside of his expertise for this. But doesn't it help when a witness is able to connect with the jury and really effective in that way?
You're absolutely right, and I probably would have objected a lot more if I had been counsel in the case as well. That also helps to keep it interesting. So if a witness is really boring, though, and it looks like the jury is not interested, that could really help you, actually, when you're on the other side,
right,
because they're not interested, they're not listening. So things that could be very important to the case could be totally ignored when it comes time to making a decision. So that's tactical as well, I think, but I would be objecting.
Well, that's a really good point, because by objecting, so many times, and especially as we've been watching here at LawNewz, people in the chat room will be like, why aren't they objecting? But sometimes it's a strategic decision not to object because you don't want to draw attention to something that perhaps the jury doesn't seem to be paying any attention to, right?
That's absolutely right. If they're not paying attention, that's all the better for you. The trick is trying to figure out when they actually are and are not paying attention. There are a lot of times when you think a jury is not paying attention when they actually are. So that's why me personally, I'd be objecting more, because I think that the testimony is going outside the scope of what's reasonable or what's relevant to the case.
I agree with you on both points. I know for myself, I've been in trials where jurors have had their eyes closed and I've assumed that they were sleeping, and it turns out they were listening. They could replay word by word when we'd speak to the jury afterwards the testimony I thought they were sleeping through. So appearances can be deceiving.
And this is an incredible case. I mean, there's so much going on with a case like this that you would think that anyone who actually got picked for the jury and is there and is getting paid for their time and service for something as important as this, sending a police officer to prison, is not something that most jurors would take lightly. So even if it seems like they're not listening, they probably are.
Very good point. And let's talk a little bit about the import of this case, because it involves some very sensitive issues for many of us, and that has to do with elder abuse and taking care of an older woman and maybe taking advantage of an older woman. She testified on Monday. But let's talk a little bit about how each side should be doing their best to represent their client in a case like this. If you're the prosecutor and you have a situation where the defense is that perhaps she had some sort of dementia, was not completely there, and that many of her claims were the result of that dementia, how do you overcome some people's prejudices that older people do in fact experience these types of memory lapses and that type of thing?
It's got to be through testimony. I mean, that's the best way that they can do it, and you live or die by your victim, really, in a case like this, because if the victim comes across as credible and someone who's really, for lack of a better term, with it or cognizant, I think that your case is significantly stronger. And if your witness comes across as not credible, I think that you have a real problem in gaining that conviction. I think the real trick here is probably the email that was not sent by her. I think that's going to be the real trick to the prosecutor's case here. If they can prove that the defendant was at her house and did actually send that email, I think that's going to be a real problem for the defense.
I agree with you 100%. And it seems like our chat rooms agree as well. They came up with a few questions for us that I want to make sure that we address before we move on to what I wanted to talk about next. LawNewz asked the question whether or not Bybee could have actually created some of those text messages. You know, some of this testimony has gotten confusing for me as well. Did you get a sense from this witness's testimony that Bybee actually was able to access the victim's text messages to create that back and forth that made it sound as though she was trying to give him everything she had?
You know, it's really tough to say. I mean, you know, because today was so uneventful and so boring and so confusing for the jury. I think it's just going to be tough to say whether or not those text messages were created by Bybee or not. I can't say one way or the other how I feel definitively based on today's testimony.
But that little piece of doubt that was clearly left in LawNewz's mind and probably in many of the jurors' mind
Sure.
could definitely be enough to, as they put the evidence on the scales of justice, as I often say in my openings and my closings, that could be a piece that could tilt the evidence oh so slightly on behalf of the prosecution. So it makes sense to put that out there at the least for the prosecutor, right?
It definitely makes sense to put it out there, but as you said, it's also not, you have to prove in a criminal case beyond a reasonable doubt, and the defense are always acting from a place ahead of the prosecution because of that. It's not a civil case where you just have to show by preponderance of the evidence or 51%, slightly weighed in your favor equals you win. The prosecution needs to prove beyond any reasonable doubt, and these kinds of droning days kind of cut against a prosecution being able to do that.
I agree with you 100%. The other question that we had come in that I think is really interesting, and you and I were talking about this a little bit before we came on, is Tuna
Sure.
Pet asked whether or not if Bybee is convicted, will that then throw into question any of the people that he has arrested that are now in jail? Will they be able to appeal their cases because this bad cop was part of the reason that they were put into jail?
So maybe. So the answer is not cut and dry. So to the extent that there is an internal investigation at the department and with the local district attorney, they would likely go through all the cases in which he secured criminal convictions. And some of those cases they may find misconduct and some not. But they would have to find misconduct associated with the particular case at issue, meaning that they would need to be able to show that there was witness tampering, that there was evidence tampering, or that conduct unbecoming of a police officer was actually conducted with regard to the particular case at issue. So you can't just use his misconduct with regard to Bybee's misconduct with regard to this case to overturn every criminal conviction that was secured through him in the past.
Yeah, it's a great question, and if you're one of the defendants who was put away because of his evidence, you're certainly looking into and having your lawyer look into any issues, because if you go back and read some of the news reports about Bybee, this is not the first time that he's had some interesting things in his past. So I think that a lot of these prisoners who may have a little bit more time on their hands than a lot of us do may be investigating their own cases, and who knows? It's a good question, and there's a real possibility that we may see some of these cases go up in appeal over it.
Sure, you definitely will see cases go up on appeal over, but if he's convicted, I mean, this isn't just a jaywalking ticket. I mean, this man is potentially going to serve a very long prison sentence for attempted murder, for kidnapping, which I find to be a fascinating charge in a case like this. The guy is if he's convicted, is proven to be a true lunatic, it seems. And so, this is the kind of thing where you'd want to go back and check every conviction that he did have to see how he got around doing what he did.
Now, here's a great question from Nellie. She asked, as a police officer, would it be misconduct for him to withdraw money even if she did give him permission? I know a little bit about this from having read the actual reports, but what's your answer to that?
He shouldn't do it. There are probably ethical guidelines locally. I don't think it's against the law, but I don't think that he should do it. I think every police department has their own ethical guidelines as to what's permissible and not permissible, and I'd say probably most police officer guidelines require you not to take gifts, goods, or services from the general public in your capacity as a police officer.
Yeah, I agree with you 100%. And I think, in fact, Internal Affairs looked into that, and that's one of the reasons that he was relieved of his duties. Remember, too, Nellie, it's not even just that he went and got the money from someone who gave him permission. Prior to this, there had been some question as to her mental capabilities. And that, don't you think, Adam, actually adds to the problem that Bybee must face? Because if she's not competent to give him the authority, and he knows she's not competent and takes advantage of that, doesn't that rise to an even worse level for him?
Sure, a police officer is a fiduciary, like a lawyer, like a financial advisor, like a doctor. You have inherent responsibilities to the general public that you interact with when you're doing so in your professional capacity. And in your professional capacity, you should not be taking money from somebody who is potentially demented. It's
Period. Right. That's right. And you make a good point. That applies to us as lawyers. That applies to anyone that has that type of a duty. And you have to be very careful to be sure that you don't overstep the boundaries of any of those relationships. You know,
right.
Doctors and patients have personal relationships. Lawyers and their clients have personal relationships. And sometimes police officers do develop relationships with members of their community. But there's a really important underlying fact that you cannot overstep that line.
I absolutely agree with you. I mean, it's just unfathomable to me.
Yeah, I'm right there with you. Now, jury selection in this case was challenging, and it's funny, in a lot of the cases that we here at LawNewz thought, oh, jury selection is going to take days and days because there's been so much coverage of this in the media. Jury selection happens like this. And then yet in a case like this, which seems to have had a little bit less coverage, it took a lot longer because so many of the potential jurors had experience with the elderly, whether they're taking care of an elderly parent or an elderly relative, or they work with the elderly in their jobs. How do you think that shows that people their everyday lives impact their ability to be jurors more than the media does?
Well, to me, from a legal perspective, it's all tactical. And when you have a case that's a circus, you want to get, both sides generally want to get a jury as quickly as possible, because the longer it draws out, the more media attention the case gets, and the more likely it is that you're going to not be able to find a jury that works for your case. With a case that has less publicity, you can be more thorough and diligent in getting your panel of jurors. And so in a case like this, because you're dealing with the elderly and a police officer that potentially had taken advantage of the elderly or allegedly taken advantage of the elderly, you definitely have a situation in which you want to be careful on both sides as to whether or not you have a jury that is predisposed to making a determination in a case like this.
Yeah, and it's funny that you're very right about the tactical decisions, because when you're going through voir dire, and it depends on your jurisdiction, but a lot of times where I practice, we actually take jurors into a separate room from the whole pool and have conversations with them. And a lot of times a juror that you might think from their answers to general questions may be biased against your case. Mm-hmm. You then sometimes when you're talking to them feel like, you know what, this juror is going to be okay for me. You just feel that connection. And so you can't always decide just simply based on the fact that they raise their hand and say, I take care of my elderly mother, or I've dealt with elderly in my job. Don't you find that to be the case?
Sure, and it also depends what kind of pool you get, right? Because their pools are fairly random, right? So if you get a pool, let's say you're a prosecutor, and you get a pool of people that all hate police officers because they've been arrested or had a cousin that was arrested, that is a pool that will take longer to weed through than a pool of people that are amenable to both sides.
That's right. And that's why jury selection is such a fascinating, one of my favorite parts of a trial, because I just find it, first of all, it's a lot less stressful than the rest. Sure. But I also find it, psychologically, just the various people and the way that their life experiences impact their ability to serve on a jury.
Sure, your case is won and lost at voir dire. My grandfather, who was a pretty renowned attorney, used to always tell me when I was a little kid that your case is won and lost in the openings. Your case is won and lost in jury selection. You don't have to get to closing to know whether or not you won a case.
Yeah, that's a scary prospect for lawyers,
Sure.
But I think it's oftentimes true. Malcolm Gladwell has a book called Blink about first impressions and how they stick. And I think it's required reading for most lawyers, because you certainly want to take advantage of that primacy effect and get in there and make a good impression as best you can for your client from that very first moment.
Right. I love Malcolm Gladwell, and I'm glad you raised it because it's so true.
Yeah, his reading is good reading for everybody, but especially for lawyers.
I agree.
What do you think are the chances that Bybee will testify in his own defense?
Next to none.
Yeah, why?
If I was his attorney, I would definitely recommend that he does not testify in this case.
Absolutely agree. Why do you feel that way?
So there are a number of different reasons. I mean, the guy has a very long career, and a lot of those things could become relevant in this particular case. If the prosecutor is able to uncover any dirt associated with other cases that he's had, that could potentially be relevant. And if there's more dirt out there, and Bobby would know, then it is not the kind of thing he wants to become public.
Yeah, I agree with you. And from what I have read, there is a lot out there that Bybee would have to deal with, and it certainly won't behoove him to put himself up there and want to testify. However, I also get the sense that he has a pretty good a sense of self-esteem. So what do you do when you have a client who is insisting, perhaps, and we don't know this to be true, but what if he's insisting that he wants to testify and you feel very strongly that it's not in his best interest? How do you handle a situation like that?
Oh man, that's a tough situation to handle, especially in the criminal context, because in the criminal context, you are dealing with people's lives. I mean, at the end of the day, it is the client's decision, and you can only recommend in the most forceful terms that you can. But at the end of the day, if the client wants to testify, there's nothing you can do but let them testify or extrapolate yourself from the case. Those are your only really two options if they're going to be that forceful. In the civil context, it's a lot more easy to have more conversation about it and to be more forceful. But at the end of the day, this is this man's one and only opportunity to really get out of a conviction. And so if he is desperate to testify, despite my or any other defense attorney's best recommendation, then that's on him.
Yeah, I agree with you. The stakes are a whole lot higher in criminal cases. And I have seen situations where when the attorney cannot get along and come up, not even get along, but come up with a good strategy in conjunction with their client, they really feel no choice but to, and let's talk a little bit about that. You can't just drop a client and say, you know what, we're not agreeing, you're out. There's a process, right, Adam?
Right. You've got to file a motion for recusal. You've got to tell the judge why you're recusing. The prosecutor has an opportunity to oppose that recusal request. And the same in civil court and criminal court. But in criminal court, it's a little more difficult to do. And so, it's tough. It's not something you can just walk away from. But you can. That is a grounds for recusal, of disagreement with your client, an unresolvable disagreement.
Yeah, and it's oftentimes having that conversation with the judge, and that conversation happens not in the presence of opposing counsel,
No.
so that you're not relaying any sort of attorney-client privilege, but that is your opportunity to explain that you're not able to work as a team for the good of your client. And that doesn't mean, I mean, I've seen it happen both ways. I've seen situations where attorneys are allowed to step out, and I've seen situations where they're not. And then I've got to imagine, I've never been in this situation personally, but I've got to imagine that it's awfully hard to then represent a client that you've tried to leave for both sides.
It sure is. It's easier when you and the client both agree
Right.
that you should get off the case as well, which isn't always the case. But it's a tough situation. It really is. And it's a very fine line in the criminal context.
Now, do you think the prosecutor here made the decision to call Ms. Soule, the victim, as one of their first witnesses? What do you think of that strategy?
You have to get it out of the way. I mean, I like the strategy. You just have to do it. And so she may not be the best witness in the world, but you kind of have to get it out of the way because she has to testify, and she's your real line to a conviction, and so it's got to happen.
Right, and I do think, I mean, she went up in her wheelchair, and she certainly appeared frail, and for those jurors who have some experience with the elderly, that might pull on those heartstrings in such a way that it could have actually helped the prosecution. And you're right, they had to call her either way, so why not put her up there, try to pull at the heartstrings, and then move on with all of this more technical evidence.
That's right, and so it's where I would have started, I think.
Now, the defense at some point, this witness has been on the stand for, I don't know, 3 or 4 hours already, and the defense at some point is going to have to cross-examine this expert or
That's
witness. Right. If you're the defense, what's your approach? Are you trying to just get in, get out, or no, go ahead.
Firm, clear but firm, right? Because you're talking about a man's life. So, and I would have mentioned this in my opening. Look, you're going to hear testimony from his soul. And Miss Soul, I'm sure, is a lovely woman, but she has issues. And these are things, this is a very important case of my client. You are looking to put him away for a lifetime. And so I'm going to have some hard questions from her. You've got to soften the jury up to it. They've got to understand that this is required. And so you need to tote the line between feeling bad about her situation and making sure that you are respectful enough of somebody who's elderly and infirm. So it's a very fine line that only the best attorneys, I think, are able to tote well.
Yeah, it's that is one of those witnesses where you might want to stay seated instead of standing for
That's
your
right.
examination, so that you don't look imposing, and keep the questions, as you said, firm and limited. Certainly not going down any unnecessary roads, but getting what you need.
That's right.
Well,
You don't want to humanize her in any way.
That's right. If you had to make a prediction, Adam, I'm going to put you on the spot. Thus far, and I know we're still in the prosecutor's case, there's a whole lot of witnesses left, so you certainly aren't being put in the spot because tons can change. But what do you think, given what we've seen thus far, about Bybee's chances?
From what I read, I think he's going to get a conviction. I don't think he's going to get all 18 convictions. I think there have been 18 claims made against him by the prosecution. I don't think he's going to get them all, but I'm curious on a personal level to see what the kidnapping conviction looks like, or whether or not he gets convicted for the kidnapping, because it is a unique set of circumstances for kidnapping. So just as an attorney, I'm interested to see whether or not that conviction actually sticks.
I feel the same way. I think the 18, one or two of them may be overcharging, but I think that he, one way or the other, is going to be spending some time behind bars. Adam, I want to thank you so much. You've been fabulous, super well informed, and hopefully we'll see you back again soon. Our audience likes you. They've been raving about you as well. So thank you very much, and we'll see you soon, Adam.
Great.